हेलो फ्रेंड्स, माय नेम इज़ श्रीनिवास एडवोकेट। आज जिस विषय पे मैं बात कर रहा हूँ दैट इज़ सेक्शन 34 कॉमन इंटेंशन। सेक्शन 34 इन चार्जशीट और एफआईआर कब आता है? जब अबव 1 person और below 5 or 4 are involved in any crime, section 34 will come into picture. The section says a common intention. When a particular members around about 2 or 1 when have a common intention to commit a crime, common intention will come into section 34. So section 34 common intention with regard to a criminal activity, it's not simply a common intention, it is a constructive mind. The common intention which has to be proved in the crime is that all the people have the common intention to commit a crime. Common intention with regard to committing a crime means that everyone has planned for a particular offense. That is common intention. They want to commit some crime and around all the people have the knowledge that they are going to commit certain crime. Their involvement should be there. Whether who is conflicted the injury or who is the main person who did the crime is not the main thing. The remaining people who are participant to that crime or commonly planned for that particular offense is common intention as per section 34. And section 34, another thing is whether constructive liability penal provision if section 34. A rule of constructive liability, essence of the liability being the exercise of common intention. It is only a rule of evidence, not a penal provision. So ये क्या कहता है? सेक्शन 34 इज़ नॉट ए पेनल प्रोविजन. जैसे सेक्शन जो भी सेक्शंस आर पुट इन एफआईआर और इन चार्जशीट, फॉर एवरी डिस्टिंक्ट ऑफेंस और एवरी सेक्शन देयर विल बी ए पनिशमेंट. फॉर सेक्शन 34 देयर इज़ नो पनिशमेंट. That is the point here. And section 30 body a rule of constructive liability, sense of the liability being the exercise of common intention. It is only a rule of evidence, not a penal provision. It gives a statutory recognition of the principle that if two or more persons intentionally do a thing, it is just the same thing as if each of them does it individually. That is section 34. And it is very much important that during the trial it has to be proved by the prosecution that pre-alleged plan was there between the parties, the accused. So accused should have planned for this particular offense for which they are being charged. Then only section 34 with regard to all the accused will come into existence. So pre-arranged plan of committing a particular crime by the person above 1 is section 34. There is judgment AR 1956 Supreme Court 732. Rasudia versus State of UP AR 1955 Supreme Court 331. Common intention referred to in section 34 presupposes prior concern, a pre-arranged plan, prior meeting of mind, and it may be inferred from the surrounding circumstances and conduct of the accused. An accused sharing the common intention is as much as guilty as the accused who inflicts the blow or actually participates in the crime. To attract section 34, it is not sufficient to prove that each of the participant culprits had the same intention to commit a certain crime. So it is not necessary that it has to prove that all the people who are participant, or it is the common intention which has to be proved by the prosecution. Each must share the intention of the other. So when they are committing a crime, each and everyone should have the knowledge and the planning, and each and everyone should have the involvement in that particular issue with a common intention. A criminal act in broadest possible sense would cover conduct of any kind on the part of a person, whether active or passive, which tends to support the common. To invoke section 34, prosecution has to establish that criminal act was committed pursuant to pre-planned by the accused. This is very much important. And section 34 will not be attractive unless first it is established that a crime has been committed by several persons. So three things are there very much important, that a common, the all persons have committed a particular crime, and crime was committed by several persons. That is second thing. Third is those people have planned for it or common intention is there. These three things has to be proved by the prosecution. Then only section 34 come into picture or it will be proved. Will not occur unless first it is established that the crime has been committed by several persons. There was a common intention of pre-planned to commit an offence, and third, there was a participation in the common intention of the offence in furtherance of the common intention. This Parichat versus State of MP, AR 1972, Supreme Court 523, page number. AR 1972, SC 535. This is the judgment about that. And another plan is a prior meeting of mind, development at spot. कई बार ऐसा होता है कि प्री प्लान्ड नहीं रहता लोगों के बीच में. दे विल नॉट प्लान फॉर एनीथिंग. when they reach to a particular place for committing an offense, suddenly they will go for a plan. Whether that is comes under section 34, that is the point. There is a judgment to the Krishna Govind Patil versus State of Maharashtra, AR 1963, SC 1413, page number. Pre-arranged plan may develop on the spot during the course of commission of the crime, but the crucial circumstance is that the said plan must precede the act constituted the offence. Another thing is that overt act of each of the individual, whether important or not, in the section 34 common intention, that is not at all important. As per judgments, Ram Bilas Singh versus State of Bihar, AR 1989, Supreme Court 1593. There must be material to show that the overt act or acts of one or more of the accused were done in furtherance of common intention of all the accused or in prosecution of the common object of the members of the unlawful assembly, as per 149 or 134. So it is not unnecessary to prove that each and every one of them had indulged in overt acts. Overt acts of all the individual is not necessary to be proved. Their common intention and their object to commit a crime is very much important. That is the important thing. Criminal activity or involved in a crime, if it does not commit directly any crime, and his involvement to the extent that his participant to the crime is also that he will be involved in the crime, like I just now told you. These are there are several points on which common intention will be proved by the prosecution, which is very much important. Section 34 has been enacted to meet a situation where members of a party act in furtherance of the common intention of all, but it was difficult to establish exactly part played by each of them. Section 34 envisages participant in some action with the intention of committing a crime. In a case where such participation is established, the section is at once attracted. This is judgment Appu versus State of Kerala, 1990, Criminal Law Journal, page number 36. These are some of the judgments which regard to say that what is common intention. So common intention proof, the totality of circumstance must be taken into consideration, arriving at the conclusion whether the accused had a common intention to commit the offence with which they could be convicted. So it has to be very much important. The circumstance of the whole case has to be taken into account to prove section 34. Simply they have the knowledge is not important. The circumstance of the case, the involvement of the accused and their participation in that particular offence, their pre-planned to do certain criminal activity is very much important, and above 1 and below 4 or 5 members, then section 34 will be invoked by the prosecution against the accused. So common intention or common knowledge of the crime and their pre-planned activity that they have planned for doing certain offence is very much important for section 34. Thank you very much, friends, for watching my video.